Hey everyone, I took a break from working out because I got a text from Oakland Councilmember Rebecca Kaplan on the copy of the letter she received from law firm Berg and Antropy, specifically relating to how they would propose to address a lawsuit brought to the National Football League and the Oakland Raiders from the Oakland Alameda County Coliseum Joint Powers Authority, and by extension the city of Oakland and the county of Alameda. And it's based on the legal concept of disgorgement. In this instance, the claim is that the National Football League illegally enriched itself via the relocation fees that were or are to be paid to it in $370 million in the case of the Raiders' attempt to relocate to Las Vegas, because of the way those relocation fees were caused to be gotten. And then they point to the St. Louis case as the foundation for what would be their case. And then the St. Louis case, which has been allowed to go to trial by the judge in Missouri. First, in that instance, the plaintiffs who brought the case, led by the city and county of St. Louis and the Regional Sports Commission, Sports Authority, are arguing that, among other things, the NFL's own relocation bylaws were violated in a number of instances by the St. Louis, now Los Angeles Rams. And the NFL tried to claim first that was not the case, they lost. And then they also tried to claim that because of the fact that the NFL owners were enjoined and to be deposed, that it was more of a local issue than a national one. Well, that argument was jettisoned as well. So that's headed to trial, and the phase of taking depositions has been activated. The Berg and Antropy argue that the St. Louis victory gives them a clear road to pursue a similar legal argument in the case of Oakland. Now, they talk about, Berg and Antropy, the way the Raiders would enrich the NFL via the relocation fee. I point out that the so-called non-recourse loan that was paid to the Raiders in 1996 of $64 million, which is ballooned to right now $160 million and is due to mature in 2036 with a value of $218 million, would be an additional way to value the Raiders' profit, base level profit, while they were in Oakland. Why do I say that? Because when that payment was made, and I said payment, not loan, the idea was that the Raiders would never have to pay back Oakland, were called the East Bay entities, as long as they remained here. It was never dreamed the Raiders would try to seek relocation again. Now, the California Supreme Court ruled in 2001 that so-called non-recourse loan was not. In other words, it's not a non-recourse loan in the standard way we look at loans. So because of that, they called it a payment. They said the Raiders had to take that money and they were to share it with the rest of the National Football League, and that was by court order. So those today arguing that the payment that was made from Oakland and the East Bay entities in the county of Alameda of $64 million that's ballooned to a non-recourse loan, those who are arguing that it's still non-recourse loan are essentially their claims are made incorrect. Their arguments are made incorrect by the history of the agreement in the courts to date. That easily applies as an additional cause of action for recovery to the Berg and Antropy argument regarding disgorgement, because the argument could be made that, hey, look, in the case of Oakland, the NFL already enriched itself once and now is trying to enrich itself illegally, that would be the claim, and is now trying to illegally enrich itself again. All right, stay tuned for more from Zenny62, and please subscribe to Zenny62 on YouTube.